Good afternoon, everyone. Thanks for inviting the entertainment lawyers to the party. This is a great vibe. Let's get one more round of applause for our last panel. That was incredible. I just want to thank Francesca and ESCA Legal for putting on this really important event. And make no mistake, this is very important that we're getting together. It's important for our business. 10 years ago, if you told a lawyer that they'd be litigating over AI-written scripts, college athletes making millions of dollars, and rappers suing over streaming algorithms, they might say to you, you were describing a movie, not their docket. The entertainment industry is evolving faster now than ever before. AI is creating music, athletes are building personal brands worth tens, if not hundreds of millions of dollars or more. And traditional IP law is being stress tested daily. For the next hour or so, we'll explore not just what entertainment lawyers need to know now, but what we can learn from our history, our experience, and current trends about what's coming next. The title of our panel is Lights, Camera, Action, Defending Creativity in Sports, Stage, and Screen. I'm joined this afternoon by a distinguished panel of industry experts, Danielle Zolot, partner at ESCA Legal, Matthew Strong, Vice President of Business Affairs and Development at SiriusXM, and Breanna Contreras, Vice President of Business and Legal Affairs at Meow. I'll give you each an opportunity to tell a little bit more about your background. Danielle?
Hi, everyone. I'm Danielle Zolot. I just joined ESCA Legal about a month ago, and it has been a whirlwind. I've really enjoyed working with everyone there and working on the brand side. Before this, I was at Davis & Gilbert for 5 years in the litigation group. Davis & Gilbert is also known in the advertising and media space, so I have some of that experience as well. Before that, I was at Manat, which is an LA-based firm. I was in their New York office, and they also do some entertainment work. And before that, I was at Cahill, which is known in the First Amendment media space. And I'm very excited to be here with everyone.
Thank you, Danielle. Matt?
Hey, everyone. Nicole, Francesca, ESCA Legal, thank you for having us. I am here at an interesting time because when I agreed to join the panel, I was at NBC Universal working in the late night team. I've since taken a new job, but you guys kept me on the panel, so thank you for that. The new job is not as a lawyer, interestingly, too, so I'll have to put my legal hat back on. But as I mentioned, I was at NBC Universal for 10 years. I started out as a marketing lawyer and then moved into the late night space. I was the lawyer for Late Night with Seth Meyers for 3.5 years. And then Tonight Show starring Jimmy Fallon for 5.5, working across Late Night, Tonight, and SNL. Also worked on scripted content. I was the show lawyer for Hacks, for the first 3 seasons, which was obviously an amazing experience given kind of the Emmy acclaim that show got. And then I think like anyone in Hollywood or Hollywood adjacent, I cut my teeth working on Dick Wolf procedurals. So whether you want to be an actor or a production lawyer, everyone kind of has to touch a Dick Wolf show at some point. And then our team also at NBC handled, besides late night specials and live events. So live events are your kind of like live from EU red carpet style productions, usually in anticipation of an award show. And then our specials, which are kind of the tentpole things that NBC is known for. So that's Macy's Thanksgiving, 4th of July, New Year's Eve, and so forth. And now I'm at SiriusXM where I'm doing business affairs, but definitely informs the legal decision making as well.
Gosh, it's hard to come after that, isn't it? I'm Breanna Contreras, as Dwayne mentioned, VP of Business and Legal Affairs at Meow. Who here has heard of Meow? Okay. A smattering. Very good. I was nervous that only one person. So Meow, for those who don't know, is a kind of immersive art company, floor-to-ceiling maximalist art everywhere. And it kind of creates like this accessible point of entry. Like you walk into a house and you're exploring and you think something is off and you open the refrigerator and you realize that it's not a stereotypical refrigerator, it's a tunnel into an alternate dimension. So that's our first exhibition in Santa Fe, New Mexico. If you've never been, I highly recommend it. Come out. We have 5 exhibition locations kind of in the Southwest. Our next one is opening in LA later this year, and then we're coming to New York after that, so keep an eye out. So I came in-house from Meow about 4 years ago, and I came from a boutique IP litigation and transactional firm. In private practice, I had really interesting work. One of our big clients was the Arthur Conan Doyle estate, so we did all of the Sherlock Holmes licensing and litigation work. I represented Holly Holm, who is from Albuquerque, my hometown, in her UFC contracts and her licensing deals. So I cut my teeth on some really interesting work and some really interesting IP litigation as well before transitioning in-house from Meow Wolf, where I kind of oversee our international and domestic kind of IP protection, licensing, enforcement, registration. I do a lot of our merchandise agreements and our artist contracts. And then I get to do like kind of the run-of-the-mill, like anything from the HVAC agreements to, whatever the case may be involving operating physical art installations with thousands and millions of people on site every year. And yeah, not as cool as Matt, but still very fun.
Pretty cool to me.
Yeah, you guys all have really cool backgrounds. I knew all this already, but it sounds even better live. And my name is Dwayne Amos. I have the privilege of serving as your moderator this afternoon. I'm a senior associate at Kasowitz LLP, where my practice focuses in complex commercial litigation. Before becoming an attorney, I worked as a talent agent. I also spent some time at Sony Music. I obtained a master's in entertainment business before getting my law degree, where I studied under the great Megan Bannigan, who we just heard from. In my current practice, I sort of split my time into two buckets. Half of my time, I'm litigating 9- and 10-figure high-profile disputes in the finance and tech industries. And then the other half, I'm dealing with disputes in the entertainment industry, where I primarily interface with our office in Los Angeles. I serve as the chair of the litigation subcommittee on the Entertainment Law Committee of the New York City Bar Association. I see some ELC members in the house. Welcome. With respect to my entertainment cases on my current docket, some of them are confidential, but one of note that's currently pending in the Central District of California has to do with the Avatar franchise. I won't discuss it on this panel this afternoon, but I invite you to Google it and to follow the litigation. All right, let's get into it. First, do we have law students in the room today? I mean, I know we have, we got a lot of law students. All right, welcome out. This is great. So when we were talking the last few weeks, we met and we were like, how can we make the best use of your time this afternoon? And we thought it would make sense to set the foundation, right, with some basics. So if IP is the asset, right, that we're talking about today, everything else builds on that foundation. So here's the first question. What are the IP basics any general practitioner needs to understand before advising a client in the creative and entertainment space? I'll kick it out to Danielle and Matt to start this one.
So we'll start by talking about copyright, which I'm sure most of you are familiar with. But copyright protects your works of original authorship, your creative works. I know we already referenced the big buzzword of AI, but this comes up because the Copyright Office has said that you need a human to author the work for it to constitute a valid copyright. So I know Matt can speak to this in a little bit, but some of the basics to understand of what can come up in copyright, especially on the litigation side, are whether your work is protectable. So I had a long-running litigation about the Febreze jingle, which is 5 musical notes. And this musician sued Procter & Gamble and their advertising agency, claiming that a song he wrote that contained those same 5 notes meant that this large company infringed his copyright. So in that case, dealing with these issues of protectability, courts have said that these basic building blocks, whether it's music or whether in an art piece it's the paint color or basic shapes and geometry, that those foundational items are not protectable on their own. So that's the first piece, that protectability piece. Also, ideas are not protectable, and this can come up in many different ways. And then we also look at whether actionable copying occurred. And to do this, you can either show that the infringer had access to your work, or you can also show that the works are so similar that it's the infringement, it's essentially obvious that they had access. So, you can juxtapose some of the cases that are out there. There was one case about the Baby Shark song, which I have young kids, so it's on in my house all the time. And in that case, access was found because that song is everywhere. It's viral. So dealing in this social media space, it is more difficult to disprove access when you're dealing with those kind of big popular items. But those issues come up too. And then, it's not so much of a business strategy, but it can be part of the equation is thinking through the possible defenses if you're on the defense side that you might have to a claim of copyright infringement. So I've dealt with implied license, which is where, there's an implication that someone could use your work. And also a big one is fair use. So I'm going to turn it over to Matt, who has dealt with that, as you can imagine, frequently in the comedy space.
I can't imagine having to listen to Baby Shark, young children, and then going to work and listening to it again. Mind-numbing. Happy to talk about fair use. I think for a lot of the attorneys in here, you're enforcing copyright. I was kind of charged with getting around it. So fair use is an exception to the copyright law that allows a party to use copyrighted content for an enumerated list of reasons. Typically in the television space, that's going to be criticism or commentary. It can be news, it can be teaching. I'll let you look up the letter of the law for the full list. But again, specifically in TV, what you're trying to say is, hey, we're going to take this third-party IP and we're going to use it in our production and say something different about it, therefore commenting on it. And that means we don't have to license it. We don't have to pay for it. We don't have to worry about executing a license and so forth. So I can kind of talk about the Tonight Show examples. Well, one, you have parody, and two, you have satire. Three, you have commentary. That's the buckets of ways you can essentially use other people's IP in a comedic context. But your analysis is really going through those four fair use factors. But I think really as an in-house attorney and a practical advisor, you're thinking about the practical risks. So we might want to use a clip from a movie. That movie is owned by, say, Paramount. It's a 7-second clip. Movie is 2 hours. I'm thinking, I'm not even going to go through the four factors because I think it's a waste of my time. I'm thinking 7 seconds, maybe that's about 0.01% of this movie. Mm-hmm. We're not using the heart of the work. Paramount owns it. The amount of time that they would have to spend, the amount of money, internal resources to sue us to use 7 seconds of a movie.
Right.
Excuse me, when they're probably also taking clips of our movies at NBC Universal is just not worth the time. So you do have that kind of academic analysis of fair use where you go through the four factors, but I think largely in-house you have that prevailing kind of practical consideration. That's incredibly important. And then when you're advising your clients, which are producers, writers, and so forth, they don't want to know any of what I just said.
Right.
They want a yes
Can
or
I
a
do
no.
it or no? Right.
Yeah.
Right.
Or maybe you can inform them of the risk. Or, teach them how they can do things in a smarter way. Mm-hmm. So again, fair use is really, there is that academic exercise, but a lot of it is just trying to think through how will this go in reality instead of getting lost in the academia of it.
Yeah, makes sense. Breanna, you want to talk about trademark?
Yep. So that, leads to kind of like a discussion of what is different about trademark as opposed to copyright. And obviously there's some overlap. Both of them are different ways of protecting underlying, in the case of copyright, underlying works, in the case of trademarks, underlying brands. And so most of everyone in the room is already aware, but trademarks, right, are words, names, phrases, symbols, sounds, and combinations of the above that are meant to protect brand, right, that are meant to distinguish the goods and services of an entity from those of another. It essentially indicates the source of the goods or services. And it's different from copyright, right, in a way, in that copyright protects physical works that are distilled in tangible form. In this case, trademarks sometimes are not distilled in tangible form. They can be for services. In a copyright setting, and exists from the moment of fixation. In a trademark setting, you can file an application in the United States, but you won't actually secure a registration until you begin using it. So, and then there's also this spectrum of distinctiveness. There's corollaries, right, in the copyright space, where you're talking about like common geometric shapes or a paint color are not subject to protection. Mm-hmm. In the trademark space, there's a spectrum of distinctiveness. You talk about like a generic mark is not as protectable as a fanciful mark, something that's completely made up. On the fanciful side, you could think of the term like Adidas or Xerox because they're completely made up and have a significance in the eye of the customer who has come to associate that specific name with that brand. On the spectrum of distinctiveness, the brands that have more fanciful marks are more likely to be able to protect those marks more broadly, as opposed to generic marks. And so when you're advising your clients, right, the idea is you always advise them to choose marks that are more likely to be protectable, both to distinguish themselves in the marketplace, but also to prevent the situation where someone claims that you're infringing their mark who might overlap a bit with yours. So that's what I spend a lot of time at Meow doing, is helping us come up with better names to protect our physical art installations or the food and beverage space within those, and coming up with something that hopefully won't get us sued and something that we can enforce against others as well.
Excellent, excellent. So we talked about copyright, we talked about trademark. I understand we're going to have a panel later on that's going to talk about right of publicity and building brands and NIL stuff. So I don't want to steal much of their thunder, but I think we would be remiss if we're talking about sort of the IP fundamentals in the toolbox if we didn't mention right of publicity and specifically NIL, which I know is a hot term right now. But essentially, we're talking about your right to make commercial use of your name, image, likeness, signature, things like that, and unauthorized uses of it, how to protect against that. Typically, an unauthorized use in this context, we're talking about unauthorized commercial use. We're seeing now, though, with AI and the rise of deep fakes, that dignitary harm is something that people are looking at as well. And although this is a paradigm of law that's typically, or at least historically, protected by state law, there are federal legislations that are being proposed now that might institute federal rights of publicity. So that's something to keep an eye on. Again, I said that, most people probably are familiar with the term NIL. Right now, it's most popular with respect to what? And specifically college sports, right? NCAA. In the past several years, it's just flipped itself on its head, because it used to be that athletes were not allowed to make money off of their name, image, and likeness. And there was some legislation, there was some case law, that found that to be unlawful. And so now they can make money, but where is the body of law that's going to support what that looks like? And so we are living in the Wild Wild West, to steal Francesca's term, right now, because it's being figured out. We'll talk a little bit more about that, but again, I know there's another panel that's probably going to touch on some of that. Matt, I think you already touched on some of the fair use stuff. Did you want to talk more about IP media law basics?
Yeah, sure. So I think this is really, when we talk about media law, I think we're talking about also First Amendment protection, but defamation. And a big part of what I did as a late night lawyer was review scripts across all these shows to see what we were saying and whether it was true. And whether it might be a stretch of the truth, and evaluating that. So I'll share anecdotally that when I became the lawyer for Seth Meyers, my manager at the time, she was like, Matt, you're going to take on Seth. And I was like, oh, okay. She was like, what do you know about defamation? And I said, I've heard of it. And then this was during the first Trump administration, so a busy time. And yeah. And the Russia investigation was in full swing. So essentially I was in the 24-hour news cycle, didn't sleep a lot, but maybe was young enough at the time to endure that. But really, it's, for someone like Seth, if you're familiar with his show, the segment that they do each night is called A Closer Look. And it's a deep dive, incisive segment similar to kind of John Oliver. And it really does kind of border on almost becoming journalism. And there's a lot of, comedic stylings throughout, but we have to make sure that everything that we're stating in A Closer Look relating to the news and what we're reporting on is true. And you can still defame someone, you can say something untrue in a joke. That's more of a journalistic example, but then you have your kind of classic monologue jokes. A monologue joke can also be defamatory. Typically, what you want to focus on in a joke is looking at the setup. The setup is what the viewer, it's what the audience assumes to be true. So if your setup is false or problematic, that's more likely to give rise to a defamation claim. The second half of the joke, people understand a joke is coming, so you have a little bit more flexibility. One kind of example that we talked about a lot, well, two in the Trump family, not to give any more attention to that, but one was Don Jr. very frequently exhibits the behavior of someone who might do cocaine. And we don't have any proof that he has done that, but it looks like it sometimes. And that is very ripe for late night comedians. So that's something where we have to be very careful whether we're making a joke or we're showing an over-the-shoulder graphic about what we're saying. Typically, you either want to go so extreme or you want to be closer to the truth. But you could say, like, yeah, like they found a boat off the coast of Miami and it had 400 pounds of cocaine. It's like, and who swam up next to it? Like Don Jr. or something like that. And you're like, okay, no human could do that amount of drugs. So that joke is probably okay. But if you kind of just asserted that he did use drugs casually, that might give rise to a claim because people might think, okay, like that is possible. It's not so absurd. Another thing is Donald Trump himself. He's actually, despite also exhibiting the behavior of someone who's drunk a lot, is notoriously a teetotaler. He's completely sober. I don't think he's ever done any drinking or drugs in his life. He's very proud of that. But again, we often want to say that he looks drunk, he's acting drunk. That's okay. He's acting drunk. But to call him drunk or to say he did, or he got drunk and beat his kids, you couldn't say that. We don't have proof of that, but we have proof of so many other things. So it's funny in the joke space to kind of be dealing on the fringes of whether our president and his son have done drugs or get drunk, but you really have to be thoughtful about the wording and how you kind of manage that humor.
Yeah, no, this is definitely, I think, a hot topic right now. The way I tensed up when you said it, I could that highlighted it for me.
It's in me as well.
Yeah, and I know you're like trying to delicately.
Yeah.
But no, this is what we're dealing with today as in entertainment law, right? Things that maybe, nobody even thought twice about in the past. Now you're like, wait a second, we need to take a closer look at that. Can you say that? And sometimes my understanding is these scripts or jokes might be coming in. Somebody might be trying to change it right before you go on air, right before you record. And so you've got to make game time decisions and do your best analysis. So, all right, we've got a general understanding. Let's get into some practice points. So if IP is the asset, then your first real kind of battleground is the contracts, right? This is where the rights are won, lost, sometimes quietly given away. So what role do contracts play in IP protection in media, entertainment, and sports, and where do they most commonly fall short? Throw this out to the group.
Well, I'll start. So I feel like I have a bit of a unique perspective amongst the group because I started out as a litigator and then I went in-house. And so I do a bit more contracting and less litigation, although I do still oversee litigation, and we have sued a similarly situated immersive art company overseas in the recent past. But what you come to learn as a commercial contractor coming from litigation is that contracts could be written a lot better if attorneys had the perspective of a litigator in writing those same contracts. Hindsight is always 20/20. You can't anticipate every potential problem, but there are certain trends that come up repeatedly in that space where if the contract had been written better at the forefront, you can prevent a lot of the headaches that come up in litigation later, or even prevent litigation from happening altogether. In my space particularly, dealing with the physical art space, so one of the things that I deal with a lot is if a client doesn't have buttoned up contracts, that might be in the form of like not securing a VARA waiver and like for a public mural that's on a wall and the city needs to take care of that space and the mural is falling apart, like it's becoming very worn, and so the city wants to beautify the space and wants to remove the mural. But if they don't have a waiver from the artist who has subsequently become of a particular stature, you're dealing with the situation where you could potentially face a claim for destruction of the mural. So making sure you have up front clearly delineated VARA rights and also licensing language to allow you to utilize the artwork in the way you anticipate. Those sorts of things should be explored in depth because you may say, like, I'm engaging this artist to do this one piece for this specific purpose, but you need to consider in the future that maybe you want to use it for other purposes. It's important to take a broad approach at the beginning and to set expectations with the artist so that later, if something pivots, that you have something to rely on for those additional uses.
Well, from the litigation perspective, some of the things that I think IP practitioners who are doing contracts don't necessarily think about are maybe these more run-of-the-mill provisions that can really dictate how you end up litigating an issue if it does go south. So us litigators tend to be the fixers that come in and maybe we're litigating a breach of a contract that, as Breanna said, would have been written very differently if you had a litigator at the front. So even basic provisions like, do you want to be in court because you want to make it a public dispute, or do you want this in arbitration to keep things private? Issues of authorship, which we're going to speak about a little later, can be hammered out in the contract. But really just some of those nitty-gritties, choice of law, where do you want to be? And so some of those things are good to think about, and they may not be, the sexiest provisions in your IP contracts, but I think they end up being litigated or they dictate how the litigation goes pretty frequently.
Yeah, often as a litigator, you're looking at a contract, now you're dealing with a dispute and it's already blown up and you're like, who authorized this provision? Why would you do this? And you wish that you had been there in the beginning. Matt?
Yeah, I was just going to say, before I was talking about fair use and kind of getting around licensing, but of course we do license things. You have to. And so I think in the TV entertainment space, you're trying to make sure that the licenses that you do have, you secure the rights that you need. And that really means for distribution. How is the show or the movie that you're working on distributed? Is it domestic? Is it international? Are you going to release it for a couple of years and then take it off the market? With the Tonight Show, again, that's kind of the example that I'll come back to a lot. What I always told all of our producers was like, all media worldwide perpetuity. Let's just like memorize that and say it constantly. So when they went to go license something like an image right before air, I was like, even if we don't get the contract, that's okay. We're moving fast. It's late night. Just get all media worldwide in perpetuity.
For the law students, Matt, what does that mean?
Yeah. All media, meaning all forms of media you can distribute the content in. Worldwide is your territory. So you can distribute it both in the US and beyond. And in perpetuity is forever and ever and ever. So just making sure that you have those necessary rights.
And I'll touch briefly on sports. With sports, protecting your IP and using contracts, we're really typically talking, especially in today's world, trademark and NIL. We're also seeing that these are being blended more, right? People are turning their names into brands and they're turning them into marks. Every athlete from college to the pros is sort of their own little startup, right? In the college world, the contracts, as I mentioned before, many of us can work from templates because people have been doing this for so long. In the college world, it's brand new. It's one thing that's interesting is that the contracts aren't even just between the athlete and the brand anymore, right? Or it doesn't just matter between the two of them because the contract needs to be what's called fair market value. The NCAA has instituted protocol. Deloitte runs a clearinghouse where they will evaluate any NIL deal that's $600 or more. And they have to make sure that this deal is actually a fair market value deal. The reason that they're doing this is because they want to make sure that universities aren't using NIL deals as a backdoor way to just pay people more money to come to their schools. You are seeing direct contracts and deals now between universities and athletes. They're allowed to do that. They're allowed to revenue share. It's about $20 million a year they can split with the athletes. And in the past, while college athletes used to get 100% of their NIL deals, that still exists, but you're seeing some more creative deals now with these collectives in the schools where they're doing in-kind arrangements and they're doing arrangements where the school is also benefiting from the NIL deal. And at the professional level, one thing to keep an eye on is how the CBAs and unions are getting involved with respect to your personal deals. In the MLB, for example, if players opt into the group licensing agreement, which I understand most of them do, then their agents aren't the ones that are actually brokering their deals. A good buddy of mine is an MLB agent. He said he's rarely ever on the phone with Adidas or Verizon or whoever else it is to do these deals. It's usually the player association attorney that's actually brokering and doing the deal with the brands. And so this means that your CBA terms are having more of an impact on your individual contractual rights. So it's evolving. What you hear from us today, you have to make sure that you're keeping abreast. That's why I led this off by saying events like this are so important because the law is literally being shaped in real time. If you want to make sure that you're advocating and advising your clients correctly, you need to be keeping up with these updates because they are updating regularly. All right, that sort of tees up a really important distinction, right? Let's talk about the difference between protecting a brand or a show like Sirius or NBC or Meow Wolf versus protecting a person. How does that differ? Breanna, Matt?
We were talking about how we were going to answer this before, and then you put me on the spot. No, I'm kidding. I think in a lot of ways it's the same, and to your point, and that segue, people become brands. So I think you have to treat them similar. I think with people, there's obviously a human element. There's a lot of client management in the legal profession. So I think you're thinking about how these decisions can impact the individual and their life, whereas the brand can kind of be separate. You can't remove yourself from your name. A brand can stay separate. So I think you probably also, you would have like a loan out company in most situations, but a brand's going to have more resources, an individual may not. So I think you just have to think holistically about what are the resources and needs of the individual versus what do you kind of like have to play with in a corporate level or with a brand that has the backing of a bigger company. But I think at its roots, like the essence of the protection and the mindset is more or less the same.
Yeah, and I'll add to it. There's actually an interesting matter I dealt with in private practice involving a relatively well-known sparkling wine producer. And I say sparkling wine because it was champagne created by a French family, but in the United States. So it was not technically champagne. And they developed a really robust brand. And you probably all had this sparkling wine at some point. And they went and they sold it, right? They eventually sold the brand. Well, the winemaker, who's a phenomenal winemaker, wanted to continue to work in that space, but then was prevented from using his own name, his last name, in promoting the fact that he was still doing these phenomenal sparkling wines. So there are real ramifications involving personal branding as an individual that a lot of people don't take into account. You can't escape from who you are. You have to be very careful and strategic in the way you protect yourself. And it's in some cases limiting, as in that specific case. And what I'll say is, like, when you're talking about brand partnerships from like an NBCU or like a Meow perspective, it's usually for a short period of time. You work out a collaboration together and then you move on. For an individual, if they associate with the wrong brand and they promote the wrong product, that can really devalue them in a way that can have much stronger detrimental impact on their long-term viability. And also when you're talking about like kind of brand partnerships in general in that space, you want to be careful, like Matt mentioned, in terms of advising your clients, a lot of client attention and coaching and advising and mentoring in terms of not only like who they should associate with, but for example, if they're going to be involved with Nike or something like that, how broadly or narrowly are they tying up their rights with respect to that? So Holly Holm, as an example, if she was negotiating with PepsiCo, she did a Pepsi commercial, what does that look like in terms of like, is she now prevented from ever being able to appear in real life holding a Coca-Cola can, for example? Over what period of time can she no longer hold it? And not even just like a competing product, but for example, a different water brand. So looking at that and making sure that when you're negotiating those contracts, you be careful in how you advise them, because they can have real world impacts, like that she can never be seen on TV holding some other product, for example.
Excellent. All right. So we talked about the foundation, we talked about contracts, and then inevitably why half of us are employed, things don't always go the way you plan, and it ends up in litigation. So how has the IP litigation landscape shifted over the past few years in the context of entertainment and media? And what are some of the greatest risks for clients? Do you want to start it off, Danielle?
Sure. So I think we're seeing a shift in some of the types of claims that are coming up. So in particular with the evolving and expanding social media landscape and the creator economy, we're seeing creative claims in this space called vibe copying. So these claims have come up where an influencer sued another influencer that she copied her vibe. The same aesthetic, it's like neutrals, very minimalist, and the court threw it out because this goes back to what I was speaking about at the beginning on what is protectable. And so a vibe was more akin to that basic building block. And so, it's interesting seeing these creative claims coming up. And I think it, brings us back to that holistic picture we were painting at the beginning, that in that sort of instance, you can fall back on those right of publicity claims, there a misappropriation of likeness claim going on if she really was, stealing her look? So those kinds of issues that are evolving have been really interesting to watch. And I think, as I said earlier, claims relating to access can be harder to disprove when you're dealing with media or a creative work that is essentially everywhere or could be anywhere. Mm-hmm. So I had this one long-running case going on where a plaintiff was saying that a large company stole his work because it played once on a college radio station and he performed it at a Pizza Hut outside of New York City. And, we knew as a litigator on a motion to dismiss phase, you can't bring in facts outside the complaint. But we knew that the production company that created the alleged infringing work the person wasn't even alive at the time that this artist was performing the work. So that's, very distinct from the type of Baby Shark, like viral claim. But we're seeing these issues relating to access pop up too. And then, really the biggest thing, and it's a gradual shift, but it's always there, is just the cost. It used to be that we could advise clients, whether on the plaintiff or defense side, if you're at this certain threshold, it's worth it to pursue, or on the opposite, it's if someone's suing you for X, even if you're not admitting any wrongdoing, this is going to cost you so much more to fight. So you should, try to work out a settlement before. And really that barrier to entry to actually file a suit or defend it through the phases of litigation is just getting so much higher. So that's really been a large part of my practice, is just counseling clients on both sides of when is it really worth taking it to the mat and either going all the way on the defense or the plaintiff side.
Yeah. No, I think you talk about the cost going up, but really what we're just seeing is that litigation, it's becoming, more complex. It's becoming bigger. We're seeing more class actions. We're seeing more corporate plaintiffs, right? And you're hitting on something when we're talking about costs. Some of these cases, there's huge discovery battles. And often this is where cases can be won or lost. There was an important decision that came out of SDNY in one of the AI cases recently, where a magistrate judge had said that OpenAI had waived attorney-client privilege with respect to certain documents that had to deal with whether they were willful infringers. And now the district judge ended up coming in and reversing that and saying they didn't waive it because just denying is not the same thing as making a good faith defense. But this is a difference of billions of dollars, right? Because if they're willful infringers, the cap goes way up. But that's a discovery front where litigation. Imagine if that had stayed, what that would have had to do behind the scenes with respect to the calculus for the attorneys, advising them, like you just said, is it worth it to keep going because we've now just opened this Pandora's box of communications we have to turn over that typically are privileged. Breanna, did you want to add anything on litigation?
Yeah, from the litigation standpoint, I'll say I had a really interesting case actually before coming in-house, and it was involving kind of immersive artwork. And there's actually kind of copycats coming up in this realm. And so one is, if you're advising your clients, register your copyrights, because as most of you know, there's the statute that allows for attorneys' fees shifting to the prevailing party in a copyright litigation matter, but only if you file before the infringement happens or within a certain period of time of publication of the original work of authorship. The reason why that comes up, though, and why it's important as both a shield and a sword is on the defense side. If a plaintiff files a copyright registration, there's a little known provision under 411B that allows you to seek invalidation of a copyright registration. So if you're in the defense position, you want to scrutinize that copyright registration and verify that all of the facts asserted in it are correct. Because if there's a material misstatement knowingly made, it can invalidate the registration. And as most of you are aware, if that happens, the case goes away. And potentially the attorney's fee shifts to the defense side, who can then use that as both a sword and a shield to say, plaintiff, you now need to settle this case on reasonable terms. That is one that we implemented in that specific case to great result for the client, and it's super underutilized. I think there's probably less than 50 or 60 published decisions by the the Register of Copyrights looking at kind of invalidation, and I think it's something that more practitioners should be aware of and utilize.
I would say when you're in-house, you just forward the email to litigation and say "see below."
Must be nice. Must be
Great.
nice.
So we're gonna switch to discussing labor and ownership disputes, which can come up. So when we're talking about labor disputes in the entertainment industry, something that comes to mind is the guilds and the disputes that can arise when it's time to renegotiate, which you may have all been hearing about. So Dwayne, what are the sticking points that we're seeing in these kinds of deals?
Yeah, so I think traditionally, right, these turned on, typical wage and benefit negotiations, but now what we're seeing is an increase in fights over AI usage and streaming back-end compensation. So if you follow this stuff, which I do, which is why I really wanted to talk about it, the WGA actually just recently put out a draft of their new deal. But one of the issues that was a sticking point in the last round of negotiations, both for the writers and the actors, is this streaming participation and residuals, right? So the old model of syndication is really gone, right? And it used to be you made a show, and then after the show was made, they can license it out to cable networks, local stations, and then when it played again and re-aired, you got a check in the mail, and it was your residual check. Yeah. And if you had a show like Friends or Seinfeld, I mean, you could live off that. Your family, your grandchildren can live off that stuff, right? But now, with the streaming companies, they tend to just keep their content, right? Like Netflix isn't trying to license their stuff out to Hulu. We're seeing some instances where maybe some of the older content will get licensed out, and who knows if the model will change. But right now, you're making a show now, your understanding is that residuals aren't typically coming, at least that's what it was before the last agreement. But there was a provision that was added to the writers' agreement where they would get a bonus or residual based on a certain metric of hitting the streaming data. So if people within 90 days of joining the platform watch the show, if a certain amount of people did that, you would get a residual for it. And then the last agreement that they just put out a couple of days ago, that went from 75 to 90%. I'm sorry, 50 to 75%, I believe is actually what it went up to. So they got a win there. And then the other big issue is obviously AI. And I know we only have 5 minutes, so I can't possibly address that in 5 minutes. But the bottom line is AI is sort of threatening job security for the writers and the actors, and they want to make sure that they're not being replaced. They want to make sure that if their work is being used to train models, right, that they're being informed about this, and ultimately they want a license for it. The writers did not get the license, it looks like, that they were looking for in this last round, but stay tuned on that. So we only have 5 minutes. I just want to kick it out to each of you, either a last word or a case that you're following as we wrap it up.
So one of the ones I've been following, there was just a recent Ninth Circuit decision. It was the Tracy Anderson, Megan Roop case over fitness alleged copyright. So I thought that one was super interesting because Tracy Anderson is a celebrity fitness trainer, and she sued a former trainer that worked for her who went off to start her own fitness brand, the Sculpt Society. And she was claiming that her fitness routines were choreography, which is a category that can get you a valid registered copyright. But based on the language that Tracy was using in her own materials, the court found that it was a mere method, which goes back to these unprotectable categories. So I thought that one was super interesting, and the Ninth Circuit ended up affirming, finding that these fitness methods were not copyrightable. But what was also interesting, going back to this discussion of contracts, was there was also a contract claim because Megan Roop had worked with Tracy Anderson, and so there was, I think she was an independent contractor, but some sort of agreement there. And that claim, I believe the parties settled. So it's just this practice point that even if you may not have copyrightable content or other protectable IP, you can always resort to the contracts that are governing the relationships to try to protect your brand. So that one's been an interesting one to watch.
I think I stopped following cases pretty quickly after I got this new job. But we had a topic about TikTok, and I can talk a little bit about this Bang Energy lawsuit that came up and was important in the social digital space, especially as it related to the Tonight Show, where we were pushing out probably 2 to 3 new digital videos, as well as derivative cut down content from the show every single day. So Tonight Show amassed over 16 billion views across platforms last year. So much of that content especially the most viral content, uses music. So aside from making fair use determinations within the show, you also have to do that on first social digital videos. A little bit harder because not as many people are watching The Tonight Show on the old boob tube these days, but they're watching it in clips on their phone, and that's where we're probably going to get a claim. We're not going to get it from someone watching on broadcast. We're going to get it from someone seeing. We're going to get the claim because a publisher or a label saw the video on their own TikTok or their own Instagram. Bang Energy, I believe, was just recklessly taking music from these social platforms and laying it over their videos. Unlike The Tonight Show as an editorial entity, making an artistic expression with the show, Bang is a commercial operation. So every video they put out, these are not editorial works of art. It's so you go buy Bang Energy. They didn't license any of the music, and did they go bankrupt?
I think there was a huge judgment.
Yeah.
Yeah, if you ever are counseling brands, just be careful in the social media platforms that the music you can use. There are differences between like the personal library and the commercial library, and I was dealing with a number of similar claims like that.
I think it's a really like hot space for claims because people just don't realize they have to license music. They think if it's on the platform, it's theirs to use. And there are distinct libraries.
So we are almost at time. Sorry to cut you short, Breanna, but I'll give you 30 seconds last word.
Oh, God. Don't put it on me to do that. No, for me, I think one interesting area, and everyone's touching on it, right, is that everything is just so much more global now. And so one thing I'm interested in and that I follow is enforcement on a global stage. There was a case brought by a Japanese art collective in the States against a U.S. subsidiary of a Chinese company that was infringing its immersive art. And so it involved issues involving the Berne Convention and the protectability of rights abroad. It also was interesting from the perspective of fixation. So one area of copyright law is whether or not something is fixed in tangible form. And if it's an immersive artwork, is it fixed? So those are the sorts of cases that I find really interesting because they're a bit on the cutting edge in terms of how do we actually enforce and protect our rights in a realm where some of those questions haven't been sorted involving new technology.
Excellent. And I love following the RICO cases. I also love Christian music, and there's a pretty big Christian music case in the RICO world right now with Chandler Moore against his former label, Maverick City Music. And it's just a good old-fashioned record label dispute, not all the bells and whistles we talked about today, so check that one out. But how about a round of applause for our panel?